Welcome back to the morning show here on Arise News. Nigeria's Supreme Court appears to be in the eye of a storm after it ruled to remove a sitting governor in Imo State while replacing him with a man who placed fourth in the final result sheet post-election. This clearly hasn't gone down well with a lot of people and may have considerably affected the perception of most Nigerians about the nation's apex court and even the entire judiciary. So what does all of that portend for an institution which is generally regarded as the last hope of the common man? For a conversation around this and some other developments in the polity, we are now being joined by Chief Robert Clarke, Senior Advocate of Nigeria and a lawyer of more than 50 years' experience at the bar. Chief Clarke, good morning. Welcome to the morning show.
Good morning, sir.
Good morning, sir.
It's my pleasure to be here.
Good morning. Good to have you on the morning show again. Well, you must have listened to my introduction. What's your take on the Supreme Court ruling in the case between Hope Uzodinma and Emeka Ihedioha in Imo State? Some persons have argued that the Supreme Court arrived at that ruling per incuriam. Even worse, some people insist that it looks most strange that the Supreme Court will give such a ruling and days after, almost a week after, there is no court judgment in the public domain stating the reasons. And people have said, how did the Supreme Court really arrive at that ruling? By some kind of strange mathematics that places a fourth man, in the first place.
Well, let me put it this way. It depends on which divide you are in this matter. If you are for the appellants, then you will be happy at the result. If you are not for the appellants, you will not be happy, and you may show your unhappiness in many various ways. But the truth of the matter is this. The Supreme Court, as the apex court in Nigeria, has the power not only to listen and take up appeals from the lower courts, but also at times the Supreme Court can sit as an original court if circumstances do permit. If I can recollect, I was part of the Onakoju's case, where this impeachment of Ladoja came to the Supreme Court, and the Supreme Court says, okay, if we send this case back to the lower court, time is of the essence in this matter. So, by virtue of the fact that our rules allow us to sit in the position of the original court, and if all the facts we need to adjudicate is before us, then we can as well take up the facts, not as an appellate court, but as a court of original jurisdiction. Now, what has happened in the present case is that at the tribunal level, the appellant stated that certain votes were not counted in his favor, that certain votes were deducted in many words. He pleaded them and laid evidence on them at the lower court, the tribunal. The tribunal was of the view that despite and in spite of the number of documents you have placed before us, despite and in spite of the witnesses you have brought, we are not satisfied that this evidence is relevant in determining the issue before us. So they listened to them, but they never gave them the opportunity of using those documents. They went to the Court of Appeal, because you see, we need to know the history that followed this case. They went to the Court of Appeal, appealed on the grounds that votes were excluded, and if those votes had been counted, they would have had majority of the lawful votes cast in that election. The Court of Appeal sat as a constitutional court of 5 members, instead of the ordinary 3. 4 of these judges ruled in favor of the tribunal's findings. There was one minority judgment. 1 of the 4 or 5 gave a minority judgment to say, look, the tribunal downstairs erred in law in not accepting the evidence of the appellant, that there was nothing wrong in the way they have presented the evidence. But the Court of Appeal also gave, probative value to those votes that were removed. Now, on appeal to the Supreme Court, the appellants, took up and urged the Supreme Court to accept the minority judgment of the Court of Appeal as the judgment of the Supreme Court. The respondents had also cross-appeal, and the cross-appeal was also taken. Now, what happened is that the Supreme Court now says, we tend to agree with the minority judgment of the Court of Appeal. And if that is what we have decided, we need now to look into the facts of those votes. Now they turned themselves into an original court of first instance and looked into that. And in the process, they determined that those votes that were excluded were lawful votes. And today, their judgment is history. So that is the scenario that has followed this judgment. The question now is, what is open to the PDP who have lost in the Supreme Court? Do they still have a right, other than that the the Apex Court had made a profound finding on this matter? Fortunately, the Supreme Court rules allow, as is done all over the world. In India today, judgments of their Supreme Court can be revisited. In the Commonwealth countries, judgments of the Supreme Court can be revisited. In Nigeria also, the Supreme Court rules allows judgment of the Supreme Court also to be revisited. But borrowing the words of Okuta, the GSC as he was then known, he says, look, we are not angels. We are not infallible. We are as mortals as you and I. Therefore, since we are not angels, we are bound to make mistakes. So if you find that we have made mistakes, feel free to come back to us. But we will guarantee you that you must fulfill some conditions before we can hear you. So what I will advise the PDP at instance is to sit down with some knowledgeable lawyers, look at the judgment. From my experience, I was privileged to be tutored by the late Fani Kayode and late Rotimi Williams. And I got a lot of inspiration from those two people. Late Fani Kayode told me, said, Robert, if you read a judgment of a judge, if you study it, you will find one mistake in it. So what I will advise lawyers of the PDP to do now, converge together, look at the judgment, and see whether you can find any fault in it, rather than allowing politics to dominate your reasoning. Get lawyers who are not pro-PDP, lawyers who are not pro-APC. Let them look at it. I believe that a mistake will be discovered. If you find that mistake, then go back to the court. The law allows you to go back to the Supreme Court and ask them that, look, in view of ABCD, I want this matter to be revisited. Now the Supreme Court will constitute a new panel. They will look into the reasons you have adduced for asking them to review their judgment. Because the Supreme Court judgment is regarded as the final of all finals. Therefore, to enable them to now look into it again, you must satisfy those criteria. That is my taking.
Thank you so much, sir, for that really important context that you just gave with regards to what options are now available to former Ihedioha and his party, the PDP. But you also made mention of the fact that the PDP lawyers would have to study the judgment, which leads to my question. So far, there's been no sign of the judgment. It has not been published. So a lot of what we are discussing in the public space is in the realm of speculation. You just referred to your tutelage under the late, great Chief Rotimi Williams and Fani Kayode, and I'm sure...
Remi Fani.
Remi Fani, thank you.
So that people don't think it's the
son.
The son.
A very important distinction.
Yes.
Thank you for that, Dr. Abati. I'm sure as a young
lawyer... It's the old papa.
Yes, sir. I'm sure as a young lawyer, your first trip to the Supreme Court was really exciting. All lawyers like myself, I'm a member of the Black Table as well, we all hold the Supreme Court in such high esteem. What do you make of this sort of opacity right now without the judgment that has reduced the Supreme Court of Nigeria to the butt of jokes and memes, and the fact that people now see our Supreme Court as a mere appendage of the APC? And what can the Supreme Court do to redeem their reputation at this point?
At this stage, I don't think I would subscribe to that statement that the Supreme Court has become an appendage of any political party. I believe that if the judgments are not available now, it is not due to any mischief. We all know, as lawyers, that we must apply for certified true copies of judgments. We are aware of the number of cases the Supreme Court judges have got to read within the past 10 days, and you can imagine the enormous work they have passed through. So the first step in the right direction is to apply to the Chief Registrar of the Supreme Court to make available certified true copies of the judgment. Because let me make it clear to you, even if you are going back to the Supreme Court for a review, you must attach that judgment when you are applying for a review, because they will want to see what you are talking about. So what I would say, rather than reading meanings into any delay in getting the judgment, or whether the judgment is ready or not, we should have an open mind. As I said, going through this judgment, a panel of lawyers have to look into it to see whether there is any way they can fault it, and to see whether that fault which they have seen can be put into the narrow concept the Supreme Court says we can tolerate you to reopen this matter.
Thank you, Chief Clarke. And on that particular note as well, what does that mean for governments or governance in continuum then? Because we're looking at a situation where you said that you believe that if his lawyers were to go back, or if lawyers were to go back and look, you believe that a mistake could be found and this can be taken back to the Supreme Court. But right now, what the people of Imo State really need is a stable government. So what exactly does this situation mean for the people of Imo State? And I say this because people have also questioned the way in which Governor Hope Uzodimma has gone about his entrance into government, if I can say that. He started off by coming out to say that he's going to be probing 3 past governors. He also ordered the freezing of all state accounts, etc. And people felt that this was maybe the wrong approach. How do you feel towards this?
Well, let me be clear. This is not the first time within the past 1 year that the will of the people have been jettisoned by the courts of law. Take, for instance, Zamfara case. What happened in Zamfara is even worse than what has happened in Imo State. Here in Imo State, you are only losing a gubernatorial position. In Zamfara State, the whole state lost all their positions. And there were no hues and cries. Let us be magnanimous in Nigeria. When the Zamfara decision was made by the Supreme Court, PDP were the most vociferous sect that claimed that the Supreme Court was an angel, is the best judgment in the whole world. Today, they are receiving the other end of it, and they are claiming that the Supreme Court is an appendage of a political party. I, as Robert Clarke, I am not a politician. I have no sympathy for politicians. Everybody knows that with me. But the truth must be said. Imo's case is not an isolated case in the hierarchy of judgments in Nigeria. And it will not be the last. As I said, rather than making a hue and cry procession that will end nowhere, let the Imo people go sit down at a table, get the best brains in the legal profession, and look at the judgment.
Well, Chief, earlier on you said that certain conditions must be met by Ihedioya's lawyers before they can go back to the Supreme Court. You already indicated one of those conditions, attaching a copy of the judgment itself. What are those other conditions? And what is the guarantee that we're not going to be faced with a situation whereby the Supreme Court will say, well, I mean, election cases are sui generis and the time has lapsed and, you know, we cannot take any further look at this matter. And then secondly, obviously, you do not think that the protest organized by the PDP across different parts of Nigeria will seem to be the best option in the matter.
Well, let me make it clear. One has to be very, very careful in opening a floodgate in the Supreme Court, where every case might, you know, tend to be relitigated on the basis of a review. One has to be very careful, because that doctrine that the judgment is the final of all finals, you know, stays. However, as you rightly said, what are the criteria the Supreme Court has laid down? Number one, if you can show that the Supreme Court had no jurisdiction to have made that consequential order, then you are on the correct footing. If you can show that there are functions official, you are on the correct footing. If you can show that there are many malpractices which are apparent to you and I, you are ready to bring it, and they are ready to listen to you. I have done it before, and I believe maybe I'm just one or two lawyers who have ever done it in Nigeria. I did it 10 years ago. Another panel was set up for me, and I lost. In that case, I said the judgment of the court was only signed by 3 judges instead of 5, which makes that a judgment a no judgment. But I was taken up on it that do I know how judgments are written? Do I know? But I tried my best. So let us look at it positively rather than allowing sentiments. My advice is that we should look at the judgment first and see whether we can find any apparent deficiency. And then we'll see what we can do from there.
Indeed, sir. Thank you. Well, since that judgment that came as a bombshell to the PDP's fortunes have been restored. They've been successful at the Supreme Court in subsequent judgments. But I want us to turn our attention to another issue of contention in the country now, and that is the declaration by the Attorney General of the Federation that Amotekun, or Operation Amotekun, is unlawful. What is your take on the legality or illegality of Amotekun and how to properly institute it?
As I said earlier, I am neither for one nor for two. One has to look at this Amotekun matter dispassionately, without any connotations of loyalty to ethnic or anything. Now, the governors of the 5 western states have not started this process following due process of law. I am quite sure, as a lawyer, before any governor of a state can spend the money of the state on any matter, it must have been appropriated by the House of Assembly. And there must be a legal basis for spending it. I can assure you, first of all, that none of these 5 governors have received any appropriation from their regional houses to have enabled them to spend the money they are spending. So what they are doing is illegal. It's unlawful. They need to go back to their various House of Assembly, present a bill. There is nothing wrong in bringing Amotekun. We all have. I live in an area where we have our own megads. Megading is something that we grew up to know. So if the governor of a state, under the Constitution, has been given the power to supervise the security aspect, there is nothing wrong in creating Amotekun. But the way and manner these governors have gone about it is wrong in law. And I think that is what the attorney, I'm not speaking for the attorney general, I think that must have been what has run in his mind. How can they call themselves the group, the forum, governors forum? It has no legal backing.
Sir.
I am aware that one of the governors said the attorney general cannot make a law from his chambers. Also, no governor has the right to make a law from his own executive table. So they all need, but fortunately, I just read yesterday that the vice president has called on all these governors to come to Abuja. And at that stage, the governors will be told that you cannot embark on a project without the backing of the law. So go and tell your people whom you are using sentiment to raise their hopes that we are going back to our state houses to go and pass the relevant laws. And a Lagos state law has no territorial to Ogun State. So outside 5 of them going, they now have to synergize themselves to be able to form a group that, you know, has been enabled by law to do so. So my take is that there is nothing wrong in Amotekun. We all need it. We know the situation in Nigeria today. And everywhere, even without calling them Amotekuns, we have our own megads. I have my own megad. My street has its own megad. And we are policing ourselves. So it's nothing new. And there's nothing wrong in it. But please, please and please, let us follow due process.
Thank you, sir. But can it not be argued that the monies being dispersed for Amotekun come under each governor's security vote and the seemingly open-ended nature of that money and the way that they choose to spend it?
You see, I am happy to hear you say it comes from the security vote. Is the security vote defined by any law? Has the governors told you how they spend security votes? That security vote is illegal. And the Court of Appeal, in one of the judgments, now says that, look, governors cannot hide under security votes to spend money as they like, and that they must be held accountable. It's a judgment of the Court of Appeal now. So if any governor feels that he can go under the guise of security vote and spend money as he like, he's living in a fool's paradise. If he does so, the law will catch up on them. So it is no excuse at all that they were spending from their security. Who authorized them to spend it? That is the question. Do they have a personal right to spend public money the way they want to spend? Don't let them fool us. Covering under security votes, that's how they steal money from us.
Well, fair enough, Chief Clarke. And on that particular note, then, I'd like to ask you what you recommend in this situation. Would you say the problem stems from the fact that this is also the first regional security network that we're seeing in the country? And how do you recommend the Southwest governors now go about trying to get this network set up? Because at the end of the day, we cannot argue with the prevalence of insecurity in Nigeria and the fact that it has come to a point where communities do believe that they do have to take security into their own hands. So what would you say you recommend? And what would you also say about the comparison of this regional security network to other community policing type of networks in the country, like Hisbah, for example, that are allowed and are ongoing across different states?
Let me be clear on this. Security is the cornerstone of any nation's development. Nigeria, as of now, is under a siege. And we need all this security outreach. Don't let us gamble with it. I am not saying that they have no right to maintain the security aspect in their state. I am saying that when and if they do decide to do so, They must follow due process. My anger is not against the formation of Amotekun. I believe so much in it. I will be the first to carry a banner asking for it. But please, and please, Nigerians should know that the rule of law is the cornerstone of democracy. Once the rule of law is being violated by the top executives who are bound to look after us, then something is wrong somewhere.
Yes,
well, Chief Clarke, sorry to interrupt you. At this point, we need to take a short commercial break. When we return, the conversation will continue. Thank you for staying with us. We'll be right back.
Welcome back to the morning show here on Arise News. Senior Advocate of Nigeria, Chief Robert Clarke, is still here with us on the program, looking into a number of ongoing issues from the Imo State elections to Amotekun that we're now on. Chief, sorry, we did have to go on a very quick commercial break. Do continue with what you were saying, sir.
Hello, what is it you're saying?
You can go ahead, sir. Sorry, we had to go on a commercial break. You can go ahead with what you were saying, sir, please.
Chief, before we went on break, you were commenting on the rule of law and the right of the people to protect themselves.
Unfortunately, I think we may have a technical issue.
Chief Clarke, are you with us?
Hello?
Yes, are you with us, sir? Before we went on break, you were talking about the rule of law and the right of the people to protect themselves, you know, after talking about, security vote being illegal. And Leila was saying if you could conclude your thoughts on that before we move to the next question.
Yeah, you see, the rule of law, adherence to the rule of law is the cornerstone of all laws. Once a country or a government does not follow the rule of law, then that country or government is doomed, because the cornerstone for stability, the cornerstone for security, and all other aspects of governance relies on the rule of law. The rule of law in this matter is quite clear. No governor or a group of governors has have the right to wake up one morning and say, look, we want to start an organization called Amotekun, without the backing of law. That is the rule of law. Before you make a public statement, you must have made efforts to get your legislative members to pass a bill to enable you to execute. Your duties are only to execute. And you can only execute what the legislatures have passed into law. The amount of money that you want to spend must be budgeted and appropriated by your regional legislature. So the governors have woefully failed to get a law upon which they could, as we lawyers say, you cannot build something on nothing. And that's what they are doing.
Well, Chief, if we may stretch that a little bit, this whole argument about the rule of law. Yes, as you have said, there are persons who have argued that there must be enabling legislation for the Western Nigeria Security Network, otherwise known as Amotekun. And you seem to agree with the idea of Amotekun or similar structures in parts of the country. But the Attorney General of the Federation is saying that security is the exclusive preserve of the federal government, and that no state government or regional group has any right to set up any structure talking about security. Now, that's not just about rule of law. It's about, who is responsible for what. Do you think the Attorney General has erred in his interpretation?
To the Attorney General, he will have made such sweeping statements. You see, security is both on the concurrent list and exclusive list. The Attorney General is only the voice of the Federation, is only the voice of the federal government. So if he is saying that security matters are solely that of federal government, I would disagree with him. Because security also, under the Constitution, the governor has been given the authority to be the head of the security apparatus in the state. So when you talk about organized forces, maybe that is what the Attorney General is trying to say. But organizations like Amotekun are not organized armed forces. So that reasoning that they can't have it is flawed.
Thank you, sir. I have to raise the issue once again, like I did with the Supreme Court. A lot of what underpins the discussion, we don't like to always address the elephant in the room, but it is a lack of trust and a perception that some animals are more equal than others. With regards to this Amotekun row that's ongoing in the country today, there is the impression that organizations like Hisbah have not been declared unlawful, where in, I believe it was 2006, 2 senior officials in Hisbah were arrested by the Nigerian police force, and they were accused of collecting foreign money to train militants. Yet Hisbah was not declared unlawful. There's also the really tragic news that we heard today of the murder of Pastor Lawan Andimi by Boko Haram, and the increased calls from the Christian Association of Nigeria that we live in a country where Christians are being persecuted. How do we address that so that we can see the current events with more clarity?
You see, I don't want to be drawn into partisan political statements. I don't want to be drawn into ethnic-oriented, thinking. I am Robert Clarke. I am a Nigerian, and I belong to no ethnic group. I belong to no religion. So if you are asking me to speak on religious matters, we are Christians. No, you can't get me talk about that. I believe in one country. But what I can tell you is that if these 5 governors had done their homework, we wouldn't be talking about, if they had done the correct thing. Fortunately, one of them is a senior advocate of Nigeria. Didn't you see it coming this way? Why did he not advise his other governors that the path they were moving to is wrong? If they had done the correct thing, you and I will not be quarreling about Amotekun. But I, as a lawyer and a believer in the rule of law, I will cry foul when I see that the rule of law is not being followed. And that's what I'm doing here.
Okay, Chief, but what I want to ask you is that do you think this is actually more of an issue about law than it is about the fact that Amotekun is being heavily politicized and being heavily turned into an ethnic subject as well, which seems to be the matter of case here? Because it can also be argued that there are parts of the law that can also be interpreted to also suggest that maybe you can also take your own security into your own hands in certain ways, the duty of Nigerians being constituted, for example. What is your take on this? Because people do have a general fear, or it is suggested that there's a general fear that maybe all of this is because if we allow one regional security network to set up and become fully functional, several others may do the same, and that may just fall into the state policing idea that is being heavily advocated for all across the country. So is it really about the legality of things here, or is the bigger picture that Amotekun is being politicized and being turned into an ethnic subject?
Well, you cannot get me drawn into an argument, as you are suggesting to me. I've told you I am apolitical. I don't believe in one political party. I'm detribalized. I don't think under religious thinking. But what I can assure you is this. All the politics that has been brought into it, let me put it this way. The 5 governors made out a hue and cry. Wale Soyinka came, all of them came, knowing fully well that you are inviting such top people when you are launching an organization that has no basis in law. That is my take. You cannot invite all the top Amotekuans to come when you know your house you are building it on sand. So I don't want to be drawn into politics. whatever people think, whether they believe it has ethnic connotation, whether they believe it has religious, I am not for that. My own, as a lawyer, I will cry out when there's a breach of law, when there is breach of due process, and that's what I'm doing.
Well, Chief Clarke, let's talk about something else, the subject of extradition, which came up when President Buhari participated.
The subject of what?
Extradition. Extradition. President Buhari, while attending the UK Africa Investment Summit in London, met on the sidelines of that summit with Prime Minister Boris Johnson. And he had appealed to the British authorities to assist Nigeria with the investigation of fugitives in relation to corruption-related matters. And I think in the papers this morning, I've also read a story referring to the EFCC chairman, Ibrahim Magu, expressing concern about getting certain persons extradited back to Nigeria from the United Kingdom in particular. Is the onus on the United Kingdom to help us go after fugitives and extradite them, or the onus is on Nigeria to take certain procedural steps and observe certain protocols before Nigeria can achieve its objective in this regard?
You see, one thing I can assure you, Nigerians are asking the Oyinbos, the British, to extradite or extradite refugees who have stolen Nigeria's money. The first question you ask yourself, in which banks this stolen money are deposited? They are all in British banks. They are all in Swiss banks. Do you think they will want you to come and take the billions of dollars from their banking system? They will tell you to go and follow due process. The most sensational case on a refugee or not is an Agoro's case. Maybe most of you were not born when it happened. If you knew how long it has become the standard case, not only in Britain, but the whole of the Commonwealth. It takes a long time to extradite anybody, except you follow due process, and it takes a long time. So Buhari is not too wrong to say, look, we have about 10, 15, or 20 Nigerians who have more money than the government of the Federation, and the money was stolen from us. Help us to get these people, but not that we will not follow due process, but it may take time. So I see nothing wrong in Buhari asking the Prime Minister to please, but I know they will not just do it without following due process.
This reminds me, sir, of, I believe it was Dr. Joe Abba that tweeted once that if the money Nigerians have stashed in the UK banks were to be returned to Nigeria, the UK would cease to exist. So we can understand some of the reluctance, as you said. But also, what is the part that Nigeria has to play? Because it's generally perceived, especially with the case between the UK and the Kingdom of Jordan, over the extradition of some gentleman who had been, linked with a terrorist attack, and that the UK refused to extradite him, saying that they cannot guarantee that his human rights would be respected, that there was a fear of torture and what have you. So it goes back to your point about the rule of law. When we are perceived as a nation that does not strictly adhere to the rule of law, what are some of the consequences internationally?
Look, international law is being determined by the powerful nations on earth. What America decides to be international law today, so be it. Whatever Russia decides is international law, so be it. Because international law is determined by the powers behind it. Now, many countries in the world do not like to extradite refugees in countries where there is still the death penalty. They have it in their own constitution that they will never, under any circumstance. Nigeria still upholds the death penalty. So if the British government says, we cannot send a refugee to you because we are not sure you will not be sent to the gallows. So each nation has its own parameters, and as such, I cannot speak for other countries. But one of the one of the reasons why many countries don't want to send refugees back is because if those countries still have in their penal codes the death penalty, they will be reluctant to send.
Thank you very much, Chief Clarke.